A very good evening to all my dear students. Welcome to today's class. We have started with Prospectus and Allotment of Securities, and we will be proceeding today for the third lecture of the same topic, Prospectus and Allotment of Securities. I hope you have revised what we have done in the previous class. And today you are sitting with your pens and papers and study material ready and excited to move forward in the chapter. So as we always follow a practice of revising what we have done in the previous class, and then we will be moving forward. Good evening, Golti Anil. Good evening, Amar, Deepika, Mustafa, Kuldeep, Amar, all those who have joined the class. A very warm welcome to all of you. I think many of the students will be joining still. So never mind, we will do a quick recap and then we will start the session further. So we have completed so far from section 23, we have completed till section 33. So 10 sections of prospectus are already over and another 9 sections are left, out of which around 5 sections we will be doing today, 5 to 6, and balance will be taken up in the next class, that is on Wednesday. So we have studied in prospectus that one is your part 1 that we are doing, section 23 to 41, which deals with public offer, and section 42, which specifically deals with private placement. After that, we have discussed the various ways of allotment of securities under section 23, which is given, that is an IPO, FPO, OFS, that is offer for sale of securities. So now my question to the class goes, which section deals with specifically for the case of offer for sale of securities? If I'm talking about OFS and prospectus needs to be issued, which is the respective section that talks about OFS. So OFS is offer for sale of securities. Absolutely correct. Section 28, which tells us when a shareholder wants to sell his securities, he will apply to the company. Sangeetwani, very good. Section 28. Kuldeep, excellent. All those who have answered it correctly. Very nice, Mustafa. Anil. So it means that when a person wants to sell his shares in the market, he will go to the company and the company is going to sell on our behalf. Whatever expenditure has been incurred will be reimbursed by the shareholder. And then we said rights issue, bonus issue, also a part of public offer as well as private securities. Definitions were discussed. Under prospectus in the previous section, in the previous lecture, we have discussed about shelf prospectus, red herring prospectus, or any advertisement which is issued as a prospectus. What did we do in case of advertisement in lieu of prospectus? That was the case where any ad is being issued, then that memorandum specifically which is being used shall contain the following important things. Any doubts in section 23, 24, 25? I hope everything was clear. Dean prospectus. Adil Khan, very good. 25, we have revised also. We have also done quick revision of section 26. So if you have any doubts, you can ask. Otherwise, we'll be proceeding further in the sections. Section 27, let's have a quick recap. So it was decided whenever we are issuing the prospectus, whatever money we have raised from the public, it shall be strictly used for that purpose only, and you cannot use it for any other purpose. But what were the cases in which I told you if I want to make any variation, then what needs to be passed? Yes, a special resolution needs to be passed in the general meeting. It shall be published in the newspaper, one in English and one vernacular, and also placed on the website of the company. Amounts so raised for buying and trading and dealing in equity shares of any other listed company. So whatever the amount has been raised, it will be written over there. And those who are the resenting shareholders who are not willing to accept this variation, they will be given an opposite offer by the promoters as per the SEBI guidelines. What was the form number for advertisement? PAS1. It shall be published simultaneously with the dispatch of notice. Offer for sale of shares, we just had a quick recap of section 28 that the members in consultation with board of directors. Children, under section 27, we are taking shareholders approval by passing special resolution. Very good, Ria and Julie Kumari, Deepika, everybody is correct. PS1 form was the correct form. Harsh Mishra, PAS2 for SR, no, Harsh Mishra, it was PAS1 for the variation form. PS2 abhi aayega. Okay. And this, yes, we were on offer of sale. So if members in consultation, board of directors. So here, board of directors approval is required. For section 27, shareholders approval is required. For section 28, board of directors approval has to be taken because there's only with their approval, the company can help us in authorizing the company that is selling the shares of the shareholder in the market, and also all the expenditures will be reimbursed. Now, this document through which the offer for sale is made shall deem to be the prospectus, and all the provisions of section 26 and 34 and 35 shall become applicable. There were 4 exceptions in case of OFS. Who is going to tell me by raising their hands or in the chat box? 4 exceptions of section 28. Okay, Aishwarya, we are doing a quick recap of all the sections. So we will do section 33 also. Okay, Aishwarya? Yes, Miss Ria.
Minimum subscription, minimum application money, and report on use of money.
Okay, well done. Utilization money also, the statement which is made by board of directors. Why it is not required? Why the utilization statement is not required in case of OFS? Can you tell me, Ria? Or anybody else? Okay, Savya. Savya would like to answer. Yes, Savya. So why the utilization money statement is not required, children? Because here I am a shareholder. I will get the money which company is helping me by selling the shares in the market. So company is not using that money. So why will company prepare a utilization statement? So minimum subscription and minimum application, which today we will be understanding in section 39, is not applicable in case of OFS. Utilization statement is not required. And any other information which cannot be gathered. You have a reason for that this information could not be gathered, then it's okay. Then that is not a problem. You don't need to include it. Say, for example, I was not able to gather certain information regarding a company and I have reasons for that. Then it's fine. And all the persons who will be bearing the cost for the offer for sale, their name shall be disclosed. Then section 29 only taught us one specific thing which says that listed companies and even unlisted public companies. I hope, Deepika, this point is clear now. Okay, you're just writing the points exceptions. Yes, very good, Deepika. Good points given by you. Adil Khan, money to shareholders ko milega. Excellent. Sangeet Mani, very good. Excellent. All the points are correct. Anil, good. Company itself decide for sale. Very good, Anil. Good answers. Mr. Chavan, good answer. Anybody else? Miss Harsh Kaur. 2 exceptions given very correctly. Well done. Very good, children. What is section 29? जल्दी से बता दो मुझे section 29 में क्या पढ़ा था हमने? I forgot. It's your revision. I am not supposed to tell. You have to tell me. And then we'll be starting with further sections. But first we have to revise as we always revise. Yes. Absolutely correct. 5 answers, 6 answers, 8 answers so far. No paper is required. Yes, not. Anil, you will say that not in the physical form. It shall be in DMAT form. Okay. So in DMAT form, Sangeet Pani, absolutely correct. Whether it's a public company, whether it's listed or unlisted companies, after 2nd October 2018, all the shares have to be in the DMAT form. Very good, Mr. Chavan, Julie Kumari. Everybody has. Yes, for every transfer of shares. Very good, Julie. Whether you are issuing the shares or transfer of shares, it has to be done in DMAT form. Kuldeep, Adil, everybody is correct. Then we did children's section number 30, in which I told you any advertisement is being issued, then the memorandum shall contain 5 things. How have we learned it? OLNNC. So OLNNC, O is object, L is liability, and double N is for names of secretaries and number of shares, and C is for the capital structure of the company. All these things shall be included. A creamy question comes in the exam for 3 marks. You can write all these points. I suppose we have done all these points. Section 23 was left with you. I'll take it up today. Yes, we have done these questions. We have done all the MCQs also. And then we did shelf prospectus, red herring, and abridged prospectus. Let's have a quick recap. Section 31. What was shelf prospectus, children? If I am planning to issue the securities again and again, then SEBI notified companies can issue a shelf prospectus every time there is no need to have a fresh prospectus. Then what does the company need to issue every time it is issuing coming up with additional subsequent shares? Yes, Anil, that's absolutely correct. We can link it so that we can learn it properly. I'm so glad to read your answers, students. That means you have been studying well, and that really makes me feel very proud of my students. Well done. Very good, Adil. Sangeet Vani, everybody is giving correct answers. Yes, Ashwarya, information memorandum has to be given before every subsequent issues, and shelf prospectus plus information memorandum is equal to deemed prospectus. So तीन जगह हमने deemed prospectus word पढ़ा है, section 25, section 28 and section 31 when we use the word shelf prospectus. Absolutely correct. What are the things to be given in the information memorandum? Information memorandum shall contain all the material facts regarding changes in the financial position between the first issue and current proposed issue. So that was all the charges that have been created in between, all the financial information that has changed and anything else that has changed shall be disclosed in the information memorandum. And here comes your PAS 2 form. किस फॉर्म में होता है इंफॉर्मेशन मेमोरेंडम? दिखाया भी था मैंने आपको पिछली क्लास में, याद है? हमने फॉर्म्स भी देखे थे. Yes, very good. Changes in the financial position, Kuldeep Nagar, absolutely. Shell prospectus is valid for 1 year and it has to be issued. Information memorandum has to be issued 1 month prior to every fresh issue, and it has to be in form number PS2. Anything about refund of money? Can anyone raise their hands and tell me about the dissenting shareholders? Any refund of money is required in this? Yes, Mustafa, good answer. Mustafa, would you like to answer this one? Sabia Khan, good answer. Who is going to answer me about dissenting shareholders? Jaya Manocha. Very good. Shamli Sharma. So many students participating. 15 days to theek hai, Miss Shamli Sharma. You should have raised your hand and tell me what is 15 days. Very good, Prerna. Again, Ria is getting good marks today. Yes, Ria.
While issuing first prospectus, someone has paid advance, then or in second prospect they want to refund their money, or has to company has to give them within 15 days.
Very good, very good. Let's give a chance to Vaishnavi also. Very good, Ria. Yes, Vaishnavi. Vaishnavi Agarwal.
Hello, am I audible?
Yes, good
Hello,
evening, child.
good evening, ma'am. Ma'am, any applicant remitting their subscriptions, or if they want, they can withdraw their application, and if they withdraw their application, company shall refund their money within 15 days.
Absolutely correct. Well done, Vaishnavi and Ria. I'm so proud of you. So if you are not happy with the changes in the financial position, you have seen the information memorandum, feel free to withdraw your money if you have paid advance money, and the company shall refund it within 15 days. Many a times the questions come related to these sections only. Section 31, मैंने आपको कराया भी था last time, question number 4 साथ ही दिया हुआ है. Presentation will be uploaded. टॉपिक पढ़ा साथ ही क्वेश्चन कर लेना बेटा, कभी नहीं भूलोगे. कीप रिवाइजिंग, कीप डूइंग. रिटन प्रैक्टिस इज वेरी इंपॉर्टेंट इन सीए इंटरमीडिएट. लेट मी टेल यू, more and more we write in law, more and more things get fed over here. Red herring prospectus. So what is red herring prospectus under section 32? A prospectus which does not include the complete details. Now here you're just trying to create a hype in the market that look, I am coming up with an IPO, I'm a new company, And I don't know how many shares will be taken up by public in the market and what will be my share price. So I'm using a book building method. Book building means a price discovery method. So I've given I'm going to raise 1 crore share capital. Anyone who is interested, please tell me how many people would like to apply in the shares of my company. Only these two important informations are missing, children. Other than this, all other obligations, all the contents of the prospectus under section 22 has to be written under red herring prospectus. And this red herring prospectus shall be filed 3 days prior to the first subscription. So before you come open the offer, 3 days prior to that, this has to be filed with the registrar. And once the price is determined, once you're closing the offer, see here it is clearly written, upon closing the offer, the real prospectus will state the total capital, closing price, with the details which were not there in red herring prospectus. It shall file the same with the ROC and SIP. So, कब आता है final prospectus? The moment the offer is closed and the final price is determined, all these details are added in the final prospectus. So, we have decided out of 10 lakh shares, we are going to 10 lakh share capital. I decided to issue 1 lakh shares at the rate of ₹10. We have determined the price from the market analysis. Now, all these details will be highlighted, variations will be highlighted in the prospectus, and any other variation. Variation means changes जो भी मैंने करे हैं RHS और final prospectus के अंदर दौरान कोई भी मैंने कुछ changes करे, variation करे, they will be highlighted with a highlighter or a pen or any other method. Then that is the only difference between RHS, red herring prospectus, and the original prospectus. All right, qualified institutional buyers help us in determining the price. And then somebody was asking a query in a abridged prospectus, section 33. Who would like to explain to the class? Yes, Jaya Manoj, it does not include the price as well as it does not include the number of shares also. Who will explain section 33 in the class? Raise your hands. You all have done it. You all know that. Harsh Mishra, Chavan, Kuldeep Nagar, all of you have given the correct answer for the previous one. Good. So section 33 talks about abridged prospectus. Is give the silent and important, salient and important features. It's a summary of the prospectus which has to go with every share application money. 3 exceptions where abridged prospectus is not required. If I have invited the underwriters, underwriting agreement क्या होता है? I'm a company ABC Limited. I said I'll not go and issue the prospectus. I have invited the underwriters who will go and issue the shares to the public on my behalf in the market. So here I don't need to. If underwriting agreement has been made with the people for the shares and debentures, then abridged prospectus is not required because they will be selling my shares. I don't need to issue a summary of the prospectus. If I'm not offering my shares and debentures to the public, means I'm doing a right issue or I'm doing a bonus issue. The next chapter, we are going to understand rights issue are given to the existing shareholders. Bonus is another incentive and additional shares I'm giving to my shareholders. I don't need to issue a prospectus to the public. My shareholders already know about my company. So here, abridged prospectus is not required. And if I'm offering again to the existing members only, so this is the case of rights and bonus issue. Here is the case of private placement where I am sending the private circulation. Section 42 is applicable over here. So if I'm doing the private circulation as per section 42, abridged prospectus is not required. If I'm doing rights issue and bonus issue, abridged is not required. And if I'm having an underwriting agreement, then also abridged prospectus is not required. Now, if Mr. A, I give you a case study, there was Mr. A who has read the abridged prospectus of the company and he saw that it has good salient features, it has a good summary about the company's financial position. But Mr. A wanted to buy shares in the company and he has requested that please give me the full prospectus. I want to read the full prospectus of 500 to 600 pages. Then what is the duty of the company? Tell me. What is the duty of the company in this case? Anyone who has requested for the copy of prospectus, because it is only a summary of prospectus, anyone is interested in knowing the full details, company shall immediately provide them copy of full prospectus before the close of subscription list. Full copy shall be given तो ठीक है, पेपर में क्या चाहिए होगा मुझे, ये लाइन चाहिए थी मुझे, that on the request being made by any person before the closing of subscription list and the offer, then only it is valid. If you are making the offer after the offer, if you're asking for the copy of prospectus after the subscription list has been closed, then it will have no meaning. Is that clear? And if you make a default in this section, then the company will be liable to a fine of rupees 50,000. Am I audible, students? I think there was in between internet got hanged. Yes. Hanji. So abridged prospectus is clear to everyone. I have read all your answers also. Absolutely correct. And if any default is made, 50,000 rupees fine will be charged for every default that you have made for the. So that means for it, I have sent 10 share applications and abridged prospectus was not accompanied with 7 share application forms. Then what will be the amount of penalty which will be charged for against the company? 10 application share forms थे जिसमें मैंने 7 applications. Very good, Julie Gamari. 3,50,000. No, Chavan, you said 50,000. That's wrong. So 7 application forms are missing. Yes, Mustafa. 3,50,000. 50,000 into 7 has to be done. Very good, Anil. All of you given the good answer. Well done. Now let's start the new topic, that is misstatement and prospectus. We have just initiated about it in the previous class also. A very, very important topic. Ghuma Firakar examiner asks you a question related to this topic, that is, what is the meaning of misstatement in prospectus? So what is the golden rule of prospectus? The golden rule of prospectus is that every prospectus gives the true and fair picture of the company's financial position. But if I'm trying to cheat you, if I'm trying to do something misleading, untrue statement, what is the meaning of the word untrue statement? Can anyone tell me in the chat box, what do you mean by untrue statement? Absolutely correct. Something which is false. Something which is false. and you're trying to suppress the material. Now, please, children, please make sure that you underline the word or between this. If any company is giving any false statements, I am making a prospectus, HK Private Limited, HK Public Limited Company, and I said Shah Rukh Khan is a director in my company. But this is a false statement. I am just trying to lie to the public so that I get too much of investment in my company. People will say Shah Rukh Khan has invested, he's the director in this company. Let's invest, let's buy the shares of this company. But what is this? It's a false statement. The moment I do any false statement, all my directors, promoters, and every person who has authorized Section 34 penalty will get attracted and we will be held liable under Section 447. आज डिटेल में समझेंगे सेक्शन 447. What is section 447? Okay. Thank you so much, Mustafa. This really means a lot. I'm so glad that you enjoy the teachings. And yes, we will be doing next chapter also together. So you don't worry. Okay. Thank you so much. All right. So where were we? So if you're doing any untrue statement, any false statement that you're using, and you are trying to cheat the public, number 1 point, here we will mark number 1 point, untrue statement. Suppress the material. Suppress karna means छुपाना. आप hide कर रहे हो. Suppress कर रहे हो means you're hiding the facts. Your financial position is very bad, but you're not telling the investors, the potential investors. You're hiding any material information. I've given you examples more also for this. Or you have omitted. Point number 3, you have failed to include some material information. Like in the last class, I told you if I have not told you in which sector I'm living, in which locality I'm living. I have just told you I'm staying in Rajouri Garden. But Rajouri Garden is very big in Delhi. What is my house number if I'm not told? That means something important information is missing. The person will not be able to locate. But I've told you my house number, but I've not told you, I've said I'm staying in house number 300 in Delhi. So Delhi is such a big city. How will you find house number 300 will be in very different locations. So you have to give complete address, house number 300, sector 9, Rohini, New Delhi, pin code. Then you have given material information. So here something material is missing. But what was immaterial? The house is located near Verka booth. So Verka booth was not very close, but it was a little far, but then it's okay. It's not your omitted material information. I said my name, Harleen, has been included in the prospectus. But the spellings that you have used is, otherwise I'm spelled as Harleen. But you have included the name Harlen or maybe Lin. So it's not material information. It's just the name spelling mistake. It's okay. But you're saying Shah Rukh Khan is included in a name. You're false. You're lying. You're not giving important information. Here is Mr. Ambani has invested in your company. You're not telling the shareholders that he has invested. You're not giving material information. Something important is missing. So all these things which is affecting the decision of investors. चौथा point. ऐसी material information जिससे मेरे फैसले को impact आए. How do you infect the decision of investors? Shah Rukh Khan has invested. I will be happy to invest. It was a false statement. You have helped me to make a bad decision. You hide the material facts. You did not tell me the name of your associate and subsidiary companies, which is compulsory for the companies to tell in the prospectus. So that means you have hidden the fact. There is one of the subsidiary in which I'm not interested. You have badly affected my decision. You have not disclosed the material information. You have 2 offices in Delhi, 1 in Bombay. It's okay. It's not very important information that you have missed. But you have not given the details about that office. You are hiding about the promoters, directors. You are suppressing the information. Then you are doing a wrong thing. Then it is said to be a misstatement in the prospectus. Anything which is false, omitted is known as misstatement. Please write down in your notes. Section 34 says, if you have intentionally done this, जानबूझकर आप कर रहे हो. What is intentionally means? जानबूझ. एक होता है गलती से मिस्टेक हो गया, पता नहीं था, by mistake हो गया. I'm really sorry for that. 2 kids were playing, the other came, and when he turned back, the other one banged into him. The child got hurt. Will he blame him? They might have a fight, but it was by mistake. Second case, the child intentionally tried to push him and try to hurt him. That is intentionally or so here it is not a mistake. You are intentionally trying to cheat. You have bad intentions in the mind. Then it is a misstatement in prospectus. Means आपने जानबूझकर अगर गलत करा है, intentional mistake है, जो से fraud कर रहे हो, तो section 34 की criminal liability hit हो जाती है. Write down in your notes. When there is a intentional mistake to do fraud or to cheat people, then section 34 gets attracted. That is criminal liability case. Write down, everyone. Written? So I wrote it here also. Okay. I forgot it's written here, children. When intentional mistake is made, section 34 comes in picture. So there was a case study of DLF company. What happened? Let's assume another name of company. There was a company, ABC Limited Company. At the time of IPO, it failed to include the name of one of its associate company in the prospectus. Now, what is the requirement of the prospectus whenever you're giving the financial information about the group companies? It is compulsory to give the full financial information about the group companies also. Group companies kaun si hoti hai, children? Associate company, subsidiary company. Can anyone tell me in the class what is subsidiary company, what is associate company? I hope you know that. Because if I'm using the word, you should know the meaning. If you don't know the meaning, then you have to ask me. Raise your hands. What is an associate company? Tell me. If ABC is having 15% interest, okay. Kapyajit has raised his hand. Yes.
Associate means the companies which have a substantial interest interest in the company, and
What is the word that
that
law uses? Significant influence, not substantial.
sorry ma'am, sorry, significant influence, and that means at least 20% or 25% of voting powers, but
Why did you
not
say
exceeding
20% or 25? Why did you say?
so no ma'am, I was saying 25% of the voting powers, but which should not exist exceed 50%.
So it's 20 or 25 now?
25 to 50.
Are you sure?
25%.
Anybody
Sorry,
else? Okay, very good, Kapyajit. Well tried, but some mistakes are there. Anybody who would like to correct this mistake? Okay, Kuldeep. Yes, Kuldeep.
Yeah, when in for associate companies, when promoters are same, if a company A and company B are managed by or controlled by or owned by company C, then A and B are associate companies.
If you're controlling. Okay. Yes, Harsh Mishra.
Good evening, ma'am.
Good evening.
Ma'am, associate company means a company in which other company has significant influence, which means control of at least 20% of total voting power.
Absolutely correct. So, Kabirjit, you said the word first correct, but then you got distracted. You used the word 25%, which is not correct. So, very good, Harsh Mishra. And Kuldeep? Yes, Harsh?
Ma'am, and also include joint venture company.
Yes, and also includes joint venture.
Yes.
And Harsh, would you like to define subsidiary company relationship also?
Yes, ma'am. Subsidiary company means a company in which holding company control the board of directors.
More than half of the voting power.
Powers and control over the board of directors.
Very good. So one is 50% relationship and other is 20% relationship, having 20% or more. So Kuldeep, what you were saying is more about the control of board of directors. You were trying to explain subsidiary companies. Now, children, these are important definitions which you should have learned by heart now because you've already done chapter number 1 preliminary. So all the important definitions are given under chapter number 1. So Wednesday, when we meet for the class, your homework is revise chapter 1. If you have any doubts, ask me any doubts in the definitions. Plus, you're going to revise this misstatements and other topics that we're going to complete today. Okay. So 20% shareholding is your associate company and 50% shareholding is being held, then it is a subsidiary company, or you're trying to control the board of directors of another. Now this ABC Limited company failed to give the name of one of the group companies, and Mr. X invested in there, he purchased the shares. So one of the investors filed a case that ABC has omitted to include important information like इन्होंने अपना नाम associate company का छुपाया है. They're trying to suppress the facts and the prospectus is misleading. So it was held under section 34 of the Companies Act that it is a misleading prospectus, and all the directors, CFOs, promoters, every person who has authorized this prospectus, action was taken against them, and section 447 penalty gets attracted. So prospectus कोई मजाक नहीं है, बहुत serious document है. 447 is a very huge, difficult penalty. I told you today we are going to learn it also in the class. Remember, we have to learn how we have to do that. Okay. So it is affecting the decision. If I have not told that ABC Limited की ना एक associate company थी PQR Limited, इसने इसका नाम बताया नहीं, हिंदी में भी समझा देती हूँ. इसने इस कंपनी का बारे में ना बताया नहीं कि ये मेरी एसोसिएट कंपनी. मिस्टर एक्स ने इस कंपनी में शेयर्स इन्वेस्ट कर दिए. बाद में उसे पता लगा कि इसकी तो पीक्यूआर एसोसिएट कंपनी भी है, पीक्यूआर में वो बिल्कुल इंटरेस्टेड नहीं था. धोखा दिया ना आपने, मुझे बता नहीं रहे हो आप. यू नॉट टेलिंग मी दैट ही इज आल्सो एसोसिएटेड विद यू. So I will file a case against you under, Mr. X will file a case against you under section 34 because you have suppressed the material fact. Now the question of the fact is whether it is a material fact or not. So hiding the name of associate, लिख लो side, hiding the name of associate companies or subsidiary companies is considered to be hiding of the material facts. It means company has not given material facts in the prospectus. Is that clear? Now, what is the defense that ABC Limited will use? What is the meaning of defense? मैं अब कंपनी हूं और मुझसे गलती से रह गया पीक्यूआर का नाम बताना, और अब ये मिस्टर एक्स ने तो मेरे खिलाफ केस कर दिया है. 447 तो बहुत बड़ा भूचाल है, जेल भी हो सकती है और पैसा भी देना पड़ेगा. सो अब मैं बचने के लिए क्या करूं? अगर तो इंफॉर्मेशन ऐसी है जो कि मटेरियल नहीं है, back to English because we have students from South also. If the information which has been omitted or suppressed was not material, for example, I failed to tell you that I have one office. I have told you I have 2 offices in Delhi, but one office is in Bandra, Mumbai also. I failed to disclose that. So it is not very material information. It is not affecting the decision of investor. Then though I can save myself if I can prove this. Another defense is if I had reasons to believe that the information was true and I continue to believe. Say, for example, ABC Limited Company has relied on its auditor's report. अच्छा, audit कौन करता है? CA करता है. कल जब आप चार्टर्ड अकाउंटेंट बन जाओगे, आप CA बन जाओगे, तो CA audit करता है कंपनी का. So audit report is made by a chartered accountant who is a professional. Now, I am the member of ABC Limited and I said, Chartered Accountant, Mr. B, please finalize my company's audit report. Now, he has given me my audit report. I did not find any mistake in my audit report and I have relied on that audit report and made my prospectus. Now, here I am relying on someone's statement. Such audit report is taken in the prospectus. The company's promoters and directors say that we had reasons to believe that whatever is written in my audit report is correct. Then they will not be liable under 447. आपको ये डिफेंस पे अपना पॉइंट प्रूव करना पड़ेगा. पहले तो हम समझते हैं डिफेंस क्या. सेक्शन 34, 35 थोड़ा सा टफ लगता है, सिंपल करके समझें. I told you a child tried to hit the other child intentionally. Intentional mistake, section 34, criminal penalty. Now, what will he say in his defense? The mother came and this child who has tried to hit him, he says, no, I did not do it. It was not intentional. Somebody banged me from the back. That is why I kicked him by mistake. Or you can check the cameras. You can see that is what you're trying to take as a defense. Apna bachav karna. How will you protect yourself? That is the meaning of defense. Now, company has come under the loop of section 34. How the company is trying to protect itself. So, two defense company will use. Number one, I had the reasons to believe that this statement is true because I was relying on a legal document, that is an audit report, for example, audit, or whatever it is. I had the reasons to believe and I continue to believe it is true. मुझे नहीं पता था कि ये false है. My company says that I never knew that this is not true. I never knew that this was not true. Okay, Anil, let me complete this and then I'll answer you. Okay, Anil? Absolutely, Mustafa, that 447 penalty is correct, but let's first understand section 34, criminal liability. And second case will be where I have relied on someone's judgment. One is I had the reasons to believe, and the second is the information was immaterial. कैसे याद रखना है? एक तो information जो missing है वो immaterial थी, influence नहीं करती, and मेरे पास reasons है believe करने के लिए कि information true. तब directors, promoters, and every person who has authorized will get protected. 447. In these two cases, मतलब ये exceptions है. In these two cases, 447 is not applicable. 447 is not applicable. समझ आ गया? Section 35, civil liability. What does it say? Anyone who has subscribed for the securities relying on misleading prospectus. अब Mr. X के पास क्या rights है उसकी बात करता है. Mr. X has subscribed for the securities by relying on misleading prospectus and he has suffered any loss on damage. मैंने आपका कहना माना और मैंने prospectus के बेस पे शेयर्स खरीदे और वो prospectus misleading था, आपकी वजह से मुझे लॉस या डैमेज हुआ, सेक्शन 35 आ जाएगा मेरे पास. If I am Mr. X who has subscribed the shares in your company on the basis of prospectus which was misleading and I suffer any loss and damage because of this, then every director of your company, every promoter, every expert, who is expert? You remember expert under section 26, subsection 5, जल्दी देखकर बताओ मुझे बुक में से कौन था ये expert? Section 26 subsection 5 में expert था जो he is not engaged in the formation of the company. He has given a written consent for the prospectus and he has not withdrawn his consent. That expert will also become liable. All these people will have to pay compensation to Mr. X who has suffered loss and damages by relying on your misleading prospectus. What does section 35 says? Section 35 is trying to tell us that any person who has relied on this prospectus has purchased the shares on the basis of misleading prospectus and has suffered a loss or damage, then every director, promoter, and expert who has authorized the issue of this prospectus will pay compensation to the person who has suffered the loss. Point number 1 ये हो गया. Point number 2 क्या है? फिर से defense. क्या defense use करेंगे हम? If it is proved when they are not liable, if the director has withdrawn his consent to act as director and the prospectus was issued without his consent. So Harleen ma'am was director in this ABC limited company and I said, look, I don't want to act as a director in your company. तुम्हारी तो company पता नहीं क्या misleading statements देती रहती है. मेरे consent के बिना issue हो रहा है. मैं जिम्मेवार नहीं हूँ. मैंने पहले ही बोल दिया. A director has withdrawn his consent to act as director. I am no longer a director in your company. And this prospectus is issued without my consent. Will I be held liable? Yes or no? The answer is no. If director says that we were not aware of the fact and we withdrew our consent as soon as we came to know by giving ad in the newspaper. Again, Harleen ma'am was director in your company ABC Limited. She comes to know she was in London when the prospectus was being issued in India. And I came to know that I am not even aware of the facts and they have done my fake signatures as a director and they are giving misleading statements. So as soon as I have come to know, I quickly gave a public notice in the newspaper that I have not given my consent for this prospectus. Either I have withdrawn my consent before issuing the prospectus, or if I'm not aware, I'm traveling, I'm somewhere abroad, and you're issuing the misleading prospectus without my authority, I have to give a public notice in newspaper that I withdraw my consent. And third is, these poor people, promoters and directors, they have relied on expert statement. Who was a competent person, he has given his written consent and he has not withdrawn his consent. यहाँ पे उसने सेक्शन 26 सबसेक्शन 5 को लेकर अपना बचाव कर लिया. उसने कहा मुझे तो जज साहब कुछ पता ही नहीं था, मैंने तो इस एक्सपर्ट के ऊपर रिलाय करा जिसने कॉम्पिटेंट एक्सपर्ट था, रिटर्न स्टेटमेंट दी और विड्रॉ नहीं करा. एक्सपर्ट ने कहा था हाँ जी ये कंपनी बहुत अच्छी है, आप इसमें आकर इन्वेस्ट कीजिए. हमने तो इस एक्सपर्ट के ऊपर रिलाय करा. सो आप डायरेक्टर एंड प्रमोटर बच सकते हैं अगर वो ये स्टेटमेंट प्रूव कर दे दैट वी आर सेल्फ हैव रिलाइड ऑन एक्सपर्ट स्टेटमेंट. सेक्शन 26 के कंटेंट में हम कहते हैं ना एक्सपर्ट स्टेटमेंट इज इंक्लूडेड. बेचारे तो खुद ही एक्सपर्ट के ऊपर रिलाई कर रहे, तो फिर वो बच सकते हैं, बट एक्सपर्ट को नहीं छोड़ा जाए. ठीक है, ये अपना बर्डन ऑफ प्रूफ कैसे है? The person who is liable has to prove the above points in order to escape penalty. आपको अपने बचाव के लिए यूज करना पड़ेगा. कोर्ट आपकी बात मानेगा या नहीं वो उनकी मर्जी. ये तो सिर्फ आपके पास डिफेंस है. इफ यू प्रूव, you have to prove these points in order to escape penalty. But if it is proved that prospectus was issued to defraud the investors, then you become personally liable. Personally liable means, write down, personal assets will also be held liable. Here your means director ke. Personal assets will also be held liable. Here your personal assets will also be held liable. So section 35 is talking about anyone who has subscribed to the shares entrusted on the basis of misleading prospectus and he has suffered any loss or damage, then every promoter, director, expert and other subscribers, any other person who has authorized the issue of prospectus, they will have to pay compensation. However, how can you give your defense if you prove that you have withdrawn your consent as a director, or once you have come to know when you were unaware and you have come to know you have given a public notice in newspaper, or you have relied on the expert statements. In all these cases, you can escape the penalty. But if you're not able, if it is proved that it was with intention to defraud the investors, then you become personally liable. सेक्शन 34 में क्या था? आपने अनट्रू स्टेटमेंट दिया, फॉल्स दिया, मटेरियल इंफॉर्मेशन को छुपाया, सप्रेस करा. सेक्शन 34 में 447 अट्रैक्ट हो जाता है. एंड यहाँ पे आप कैसे प्रूव करते हो कि इंफॉर्मेशन वाज नॉट मटेरियल and you had the reasons to believe and continue to believe that it is true. So the chart for section 34 and 35 is criminal liability. Every person who has authorized the issue of prospectus will be liable under 447. Excuse me. I'm sorry. Every person who has authorized the issue of prospectus will be liable under 447. If you use immaterial and reasons to go around to believe to true, then you can be escaped from penalty. Civil liability. If any person has subscribed to the securities and has suffered loss and damage, then every company, director, proposed director, promoter, expert, everyone who authorized the issue of prospectus, they will have to pay compensation to the investors. And what is the defense? I have withdrawn my consent to act as a director. I believed on consent under section 26(5), that is experts consent, and it was issued without my public notice means जो हमने लंदन वाला example करा है, that I was in London and director was in London. He never knew that the company is issuing the prospectus. Then he has given a public notice in the newspaper and withdrawn. Quickly open your the directors who are going to act as a director, somebody who is a proposed future directors. He will be acting as a director in the company. I hope I'm audible. It's showing me my internet is unstable. I hope I'm audible, students. Okay. Thank you for confirming. Okay. फटाफट से देख लेते हैं सेक्शन 34 and 35 यहाँ से भी. So misstatement in prospectus is based upon the fact that is at most good faith. All the contracts of insurance are made on the basis of Judicial facts. That is a Latin word. It means all the parties who are dealing in good faith and all the facts have been disclosed. Like when you make an insurance contract and you are doing a life insurance, you are 89 years old, but you're hiding and saying that I'm 70 years old. That means you're trying to do cheating. So under insurance contract, this word is used. Uberme fights, that is a Latin maxim, which means at most good faith कि आप कुछ भी facts अपने छुपाते नहीं हो. Similarly, prospectus company का जो है ये contract है company का outsiders investors के साथ, तो इसको good faith में and all the material facts have to be disclosed. The purchasers should be given true and correct picture of the facts of the company with full accuracy. Scrumptious accuracy means full accuracy के साथ आपको ये अपना prospectus करना, and not state the facts which are not strictly correct. Don't write something which is not correct. Okay. So what is misstatement? I explained you this definition from my presentation. If anything is false, wrong impression, गलत है, झूठ है, suppressed है, वो misleading हो जाएगा. If the statement is misleading, any inclusion or omission is likely to mislead. अब हम यहाँ पे interpretation पढ़ेंगे. Judicial pronouncements क्या होता है? On the basis of certain court decision, we have taken the meaning of these facts. How do you decide whether it is a misleading fact or not? So one of the case, Henderson versus Lacan, it was written, directors and their friends have subscribed large portion of the capital and now offer to the public the remaining shares. Actually, each of the director has subscribed only 10 shares. Here the statement is a misleading one. So आपने prospectus में ये लिखा कि सारे directors and उनके friends ने large portion of the capital subscribe करा and remaining is given to the public. Actually, they have only subscribed 10 shares, so you're lying. झूठ बोल रहे हो आप. आपने कहा 99 shares director ने लिए, उसने सिर्फ 10 share लिए, तो झूठ बोल रहे हो. False. यहाँ पे क्या है? False statement का example. पहला वाला कौन सा case है? False statement का example. Second वाला case है hide करना. Company was paying very important case, Rex versus Carlson. Rex versus Carlson, name of the company. A company was paying dividends. However, actually the company was having a lot of losses. And they used to write back the past provisions to the credit of the P&L account. Here you're not disclosing the correct facts. मैं आपको simple language में समझाती हूँ. एक company थी ABC Limited. It was having huge losses. Year 1 में उसको 1 lakh loss हुआ. Year 2 में 2 lakh loss हुआ. बहुत सारे losses हो रहे थे उसको. But prospectus में उसने लिखा है कि company ना regularly dividend देती. In the prospectus, they have written that the company is paying dividends to the shareholders. Now, when you will do chapter number 8, declaration of dividend in Companies Act, you will learn that the dividend over there is paid out of the real profits, not out of the capital profits or out of the reserves. Here, the company was paying the dividends out of the reserves that they have created. Surplus and reserves में से दे रही थी. Actually, में तो company को loss हो रहा था. Company was actually in real having losses. So there were no real profits. So you are hiding, you are doing a misstatement. आप सच को छुपा रहे हो, बता ही नहीं रहे हो शेयर होल्डर्स को कि हमारी कंपनी तो लॉस में. सिंपल लाइन, झूठ लाइन लिख रहे हो कि हम तो डिविडेंड देते हैं. So, पहला केस फॉल्स स्टेटमेंट बोला, शेयर होल्डर्स ने लिए ही नहीं है ज्यादा शेयर, सिर्फ 10 नहीं है, आप झूठ बोल रहे हो. कंपनी डिविडेंड दे रही है जबकि कंपनी के एक्चुअली में लॉसेस हैं. सो दैट मींस यू आर नॉट टेलिंग अ ट्रू पिक्चर. ambiguous statement. Ambiguous means clarity nahi. It's not clear. Yes, Mr. Gupta. Swastik, you want to ask something? Yes, Anil.
Good evening, ma'am.
Good evening.
Like in case of exceptional cases, like whether if we fail to get idea regarding whether it is done intentionally or not,
So
in that
then
case,
see child,
what's the
it's law में ना एक चीज होती है that burden of proof lies on the person who has done the mistake. So you have to give a very valid reason that it was not intentional. All these things are based on big missions that we file in the court. Have you seen the movies? In movies, they show you that please keep your hand on the Bible or the Gita and say whatever you're going to say. It'll be true. You will not be lying. Have you seen these kind of scenes in the movies? The way the court actually acts. So all these are
yeah.
actually just memorize and visualize those pictures in your mind. That if a director or company has done, they will be dragged to the court and they will be judge sitting over there and he will be taking the final call. Whether he trusts your facts, whatever you're showing, whatever submissions you have made or not, he's trusted. All these points have to be proved in the court. Okay?
Ma'am, one more case. In case of civil liability, we have an exception, right?
Let me complete criminal liability from the module, then we'll come.
Okay, ma'am.
Okay. Okay. So misleading through ambiguous statement. Ambiguous means there is not clarity. That means you're not clear about something. So prospectus of a manufacturing company says that the present value of turnover is 1 million pounds. Statement was true only if the production capacity is considered, but untrue if the present production capacity and utilization. So statement which the director knew bears more multiple meanings. Simple example karte hain. A offers to sell oil to B, Indian Contract Act. All my CA Foundation students will remember this now. A offers to sell oil to B. What kind of oil, ma'am? Coconut oil, mustard oil, olive oil, amla oil? Which oil? There is ambiguity. You have not told me which type of oil. Something which has multiple meanings. जिस चीज के बहुत सारे meaning निकल सकते. A tells B, I want to buy a chocolate from your shop. What chocolate? He picked up, not a 5-star, he picked up the biggest Dairy Milk shelf, 185 rupees, and said, please pay me 185. He said, no, I don't want to buy this Dairy Milk shelf. I mean 5 rupees per. So, chocolate is a full-fledged word. You have so many chocolates. There is ambiguity. Please tell him, I want to buy a Cadbury Dairy Milk or a Perk or a Kit Kat, whatever you're looking for. So Kit Kat also comes small, big packets. What are you looking for? Multiple meanings नहीं होना चाहिए, clarity होनी चाहिए. इसी तरह से prospectus में clarity होनी चाहिए. It should not have multiple meanings. So I understand we have done too much technical stuff. I give you a break over here. Just give a fair reading of section 34 and 35 from the module. After the break, we will be first completing 34 and 35 from the module. Then we will be doing 36, 37, and 38. Then we do certain examination questions, and then we wind up with section 39. All right. So let's take a break here. Sir, we are taking a break here. Anyone having any doubts? Raise your hands and ask your doubts. Kuldeep, Mustafa, all your previous answers are correct. What is Mr. Chavan asking? Yes, definition of expert is correct. Yes, Mr. Keshav.
मैम मेरा डाउट नहीं है, एक्चुअली एक रिक्वेस्ट है। मैंने आज ही ज्वाइन किया है क्लास आपके, तो क्या एक्चुअली मुझे व्हाट्सएप ग्रुप में ऐड होना था?
Okay. I will tell Ajit sir, he will send you the WhatsApp link and you can. Nisarg sir, technical support sir. Sorry. So sir, just send their link for WhatsApp. Okay, Keshav, it will be done.
थैंक यू मैम।
Welcome. Yes, Jaya.
I'm in section 35. Omission can be intentional.
Your voice is breaking, Jaya. You mean to say in section 35, it's not intentional? This is what you're saying. Yes? So, see, children, whenever a question comes related to section 34 or 35, if there is a misstatement and liability, both the sections should be covered. Okay? Yes, Sangeetwani, you'll get all the notes which we are sharing with you on this platform. You will get all them uploaded.
Yes, ma'am.
Okay. Clear? Jaya, is it clear? Mustafa said, ma'am, you said writing practice karni hai, but how to do write from the study material? So, Mustafa, it means that once you are done with the chapter with me, then you go through all the descriptive questions which are given at the back of the study material. You pick up the question and do write it by yourself. Once you're thoroughly done with one chapter, then you go to the RTPs and MTPs, pick up the question respectively from that very chapter and do the writing practice. Okay, that is how you have to do the writing practice. Clear? What is Satish asking? Okay. Anybody again having any doubt? Can we call red herring a temporary prospectus? Vaishnavi Agarwal. So Vaishnavi, yes, it's a draft prospectus. You not call the word temporary, it's a draft prospectus. And once the decision, final price and number of shares is determined, then the prospectus becomes the final prospectus. Swastik Gupta, you can also find that link is being shared over there now. All those students who are asking for the WhatsApp link, sir has shared the link in the main chat. Kindly read it from there. Yes, Shamli, that's correct. If it is misleading, both the sections 34 and 35 will get retracted. Section 35 is largely Section 35 is largely when you have suffered any loss. Then only compensation. अगर आपने loss ही नहीं suffer करा, I am a subscriber and I read a prospectus and I found that it's misleading. But I have not purchased any shares. Then why am I asking for Section 35? But if it is a misleading, Section 34 retract होगा ही. Okay? But if I have not suffered a loss, then Section 35 will not get retracted. But you can give a reference. There's no harm in giving a reference. Let's try solving one question. No, first I will explain you peak versus don't make a case. Okay. So effect of misleading, all this you have read. Against the company will end the contract and damages will have to be paid. What is the meaning of recession? Please write down. Recession means end the contract. Effect of recession means end the contract. And the remedies for misrepresentation and prospectus against the company and others, civil liability under Section 35, they will have to pay compensation. And the person authorized to issue the prospectus, criminal liability under Section 34 and damages for deceit. Deceit का मतलब होता है cheat करना. जो भी मुझे आपके धोखे से, चीट जो आपने मुझे करा, जो डिसीट करा, उससे नुकसान हुआ, उसके लिए आप मुझे damages पे करो. Now all these words, children, recession, damages, deceit, have the same meaning as you have done under the Indian Contract Act. Okay, you remember Indian Contract Act, Section 72 of Indian Contract Act, where we have studied about how a person breaches the contract and then he is liable to pay the damages. So a person who has purchased the shares on the basis of misleading prospectus has the right to end the contract. Recision of the contract means to end the contract. The agreement becomes voidable. Who will explain me the meaning of the word voidable? Means it is voidable at the option of one or others and not at the option of others. Means if you want, you can end the contract or you can keep it as it is valid also. If the court accepts his application, company will remove his name from the register of member and return this money. Compensation will be as per Section 75 of Indian Contract Act. You remember we have done under Indian Contract Act, ordinary damages, special damages. So all those same principles will be applied. But when is the right to rescission not available? When you cannot end the contract? If will not be available to the subsequent purchasers of the shares from the market. Now, this is very, very interesting. There is a leading case law, Peak versus Gurney. What happened in this case law was, there was Mr. X who purchased the shares when ABC Limited came up with an IPO. So when you are purchasing the shares from the IPO means from the primary market. And later Mr. X sold these shares to Mr. Y. So that means Y has purchased the shares in the secondary market. And Y later on said that I want to cancel the contract because there is a misleading prospectus. So law says Mr. X has a right to cancel the contract because he has purchased the shares on the basis of prospectus. Y को थोड़ी ना prospectus पढ़ना है. अगर मैं IPO में जा रही हूँ तभी तो मुझे prospectus पढ़ना है, IPO या FPO या OFS में या राइट्स इशू बोनस इशू में. अगर मैं मार्केट से शेयर परचेज कर रही हूँ फिर थोड़ी ना मुझे प्रोस्पेक्टस पढ़ने की, मैं तो किसी से शेयर ले रही हूँ. सो आई एम बाइंग ऑन द ट्रस्ट ऑफ दैट पर्सन. Then I don't need to cancel the contract. Similarly, the people who have subscribed to the memorandum of association, they cannot seek this relief because the company is not in existence when they have given their signatures to memorandum. So they are not influenced by the statement and prospectus. So tomorrow the subscribers to the memorandum of association of ABC Limited said that we also want to end the contract. They said, who are you? Your company was not even in existence. You're the promoters of the company. You only made the company and further enhanced it. So those people who have signed the memorandum, they cannot end the contract. So rescission of contract right is available only to those who are buying the shares on the basis of IPO. This illustration will make it clear. All the statements contained in the prospectus issued were literally true. कहते हैं prospectus में सारी चीजें सच बताई गई थी, true बताई. It was also stated Vedant Tiwari, you can refer to my notes, which I have shared with you, that presentation. And along with that, whatever I'm making you write down, please keep writing down. All right. Simultaneously, module has to be referred. You cannot escape from the module, but keep marking down the points the way I tell you in the module also. All the statements were literally true. It was said that the company has paid dividend for a number of years, but there was no disclosure that the dividends were paid out of the capital profits. Tell me, children, is there a misstatement or not? Allotee wants to void the contract, saying that the prospectus was false related to material particulars. Can he void it? Yes or no? Absolutely yes, because you have not known the source on the basis of which dividends are being paid out. So the non-disclosure is a concealment of material fact. Company is required to pay dividend from the trading profits. However, in the exceptional circumstances, it can pay out of capital profits. So material misrepresentation, you have to tell them from where we are paying the dividends. So accordingly, Allotee can avoid the contract. So if there is any fraud, aggrieved party get the right to claim the damages. What are the claim for the damages? How you can claim? If there was a misrepresentation, अब ये सारे section 75 के towards लेके जा रहे हैं. Person has acted upon it and he has suffered a loss and damage, then it will be civil liability under section 35. Who is going to be held liable? Director of the company, authorized himself to be named in the prospectus, or has agreed to become director later on. So ये इसको क्या बोलते हैं? Proposed director. Promoter authorized the issue of prospectus and the expert given under section 26. They will be liable to pay the damages. ये सारी exceptions हम वहां पे पढ़ चुके हैं बेटा. अगर मैंने consent withdraw कर लिया था, कौन बताएगा मुझे exceptions of section 35? What is the defense when I'm not held liable? Who will tell me? Raise your hands and tell me. Okay, first two exceptions by Mr. Chavan.
A person shall not be liable in case where he has withdrawn the consent or where it was issued without his consent,
Very good.
or in case where it was issued without his knowledge, then he has withdrawn the consent by giving a public notice,
Excellent.
or he has proved that he has relied on experts' statement.
And for section 34 also they have given the 2 points. He had the reasons to believe that the statement was true, or he has relied on the correct copy of the official document. यहाँ पे लिख लो, for example, audit report. जो मैंने आपको example दिया था, children. You can write down, for example, on the audit report if you are relying. So when do you become personally liable? All these people under subsection 1 will become personal liable, means there is no limitation on their liability for all the loss and damages that they have suffered on the basis of prospectus. It is proved that the prospectus, if it is was to defraud the creditors. A prospectus issued by the company contains certain misstatements. On becoming aware of the fact, one of the experts, Anilesh, who had given his consent, gave a reasonable public notice to withdraw his consent. Is it possible for Anilesh to escape penalty? कहते हैं पहले आपने consent दे दिया, जब आपको पता लगा कि misstatement है, now you are withdrawing your consent and said that the prospectus was issued without his knowledge. So no person will be held liable if he proves that it was issued without his consent or knowledge, or on becoming aware he has given a reasonable public notice. So he can escape his liability, but whether it will be escaped or not, that is in the hands of the court to decide. Okay, फिर हमने section 34 भी सारा पढ़ लिया, वहां से भी फटाफट से उस पे आ जाते हैं. Illustration पे, allotee of the shares brought action against the director for the false statement. Director said that the statements were prepared by the promoters and he simply relied upon it. Will the directors be held liable? Of course they will be held liable. Promoters तो आप ही के बंदे हैं ना, so they will be held liable because section 34 imposes a criminal punishment on every person who has authorized. Director will not incur any liability if he proves that he has relied on the statements prepared as a valid ground for a director. No such exception. ऐसी कोई exception नहीं. Is that clear, everyone? Person responsible will be held liable for action under section 19. अब ये misrepresentation के cases बता रहे हैं आपको, Indian contract. The requirement to claim damages, this is very important. In order to claim the damages, it's very important that there should have been a fraudulent misstatement in the prospectus. You are the original lottee and you have seen the prospectus and you have actually been deceived. Deceived का मतलब लिख लो बच्चा, cheated. अगर आपके साथ धोखा हुआ है, cheating हुई, तभी माना जाएगा कि आप damages claim कर सकते. Gurne issued a fraudulent prospectus on behalf of the company. Gurne ने prospectus issue करा. Shares, no shares were purchased by Peak at that. Peak purchased 2,000 shares from the stock exchange. Later on, he filed a case against the directors on the basis of prospectus. It was held directors were not liable because shares were not purchased on the basis of prospectus. So, इस case के नीचे आप लिखेंगे ये वाला point. Only if shares are purchased in primary market at the time of IPO and you are relying on prospectus and buying the shares, then you can file a case. If there is a fraudulent prospectus. But if you buy shares in secondary market, or we say from stock exchange, then you are not authorized to take an action on the basis of prospectus. Write down these points. Clear? Shall I rub it? Yes, Harsh, that's correct. Clear? Let's start with section 36 from my presentation. And then we'll be coming back to these questions. Section 36. Now, children, 34, 35, 36, 37, 38, we prefer to do all these sections together because they all are related with penalties and the major penalty of fraud, that is 447. So, section 36 also attracts 447 penalty. But what is section 36? Any person who either knowingly or recklessly का मतलब क्या होता है? Carelessly. ऐसे ही बोल दिया, ऐसे ही कह दिया. मैंने कहा आज आपकी इकोनॉमिक्स की क्लास है, इसके बाद आपकी अकाउंट्स की क्लास है, ऐसे ही कह दिया अपने मन में आ, या फिर जानबूझकर झूठ बोला. सो ये क्या होता है? रेकलेसली. एनी पर्सन, हमने प्रोस्पेक्टस में ऐसे ही बोल दिया, हाँ जी हमारा डायरेक्टर शाहरुख खान, ऐसे ही अपने आप से बोल दिया मन से. कोई भी स्टेटमेंट बोली या प्रॉमिस करा या forecast करा which is false, deceptive or misleading, or deliberately you're trying to conceal any material facts, then to induce another person, दूसरे बंदे को उकसाने के लिए, A tells B that look, PQR company is coming with a prospectus and you know they have good shares in that. Shah Rukh Khan is going to act as a director. Misleading बातें, deceptive, झूठ बातें अपने आप से, deliberately concealing the material facts. Somebody which is not very known to Mr. B and saying that that person is part of PQR, just trying to conceal the facts so that B should buy the shares of the company. Induce करना means influence करना, किसी को प्रभावित करना. So A अगर B को ऐसी statements बोल रहा है जो recklessly बोल रहा है, false बोल रहा है, misleading है, for him to enter into an agreement for buying, acquiring means buying, disposing means selling, for either buying the shares or selling the shares or for subscribing the securities of that company. Or any agreement for the purpose to secure a profit to any of the parties from yield of such securities or fluctuations in the value of securities. You want to gain any profit from these securities. the security price today is 10 rupees. You know that the price will be 20 rupees tomorrow. Or today the price is 20 and you know that the price will be falling down to 10. So you want to enjoy these fluctuations in the prices. You want to earn a profit out of that. So for example, A tells B that please go and buy my friend's house, which is for 5 lakh rupees. Actually, the value is 3 lakh rupees. So you're inducing the person to pay more so that you can earn lakh rupees profit. So such kind of agreement where you want to earn profit for any of your parties, or you want certain credit facilities from the banks or financial institutions, that's why you are inducing the person to buy the shares. आपको कुछ उधार चाहिए, पैसा चाहिए, क्रेडिट फैसिलिटीज चाहिए बैंक से, इस करके आप इंड्यूस कर रहे हो किसी को कि वो शेयर्स बाय करे मार्केट. तो ऐसी कोई भी तीनों में से एग्रीमेंट, एन एग्रीमेंट टू इंड्यूस द अदर पर्सन टू बाय और सेल द सिक्योरिटीज ऑफ अनदर कंपनी, एन एग्रीमेंट to make profits for the other parties from the yield of securities or fluctuations in the prices, or any agreement in order to obtain any credit facilities from the banks or institutions. In all these cases, the person who is making such false statements shall be held liable under section 447. So क्या कहते हैं section 36? 3 type of agreements. Number 1, inducing the person to enter into agreement for buying the shares, or inducing him to make certain profits for your friend, or with the view to obtain credit facilities. In all these cases, you will be punishable for the fraudulent investing, asking the other person to invest their money for fraudulent reasons. You will be liable for the action under section 447. So 447 की जो लिमिट्स दी गई हुई है उसके अंडर आपके ऊपर एक्शन ले लिया जाए. क्लियर हो गया सेक्शन 36? सेक्शन 37. सेक्शन 37 तो बहुत ही सिंपल. एक्शन बाय अफेक्टेड पर्संस. कहते हैं जो जो लोगों को अफेक्ट हुआ है, जिनके साथ नुकसान हुआ है, वो क्या करेंगे? वो केस फाइल करेंगे. वो केस कैसे फाइल करेंगे? Yes, Anil, all those people, any person do all those people. Suit can be filed means case can be filed. A suit के ऊपर लिख लो. A case can be filed or any other action can be taken by people who have suffered penalty under section 34, 35 or section 36. So if you have been a sufferer and you want to take an action against the company under section 34, 35 or section 36, then if Mr. X is a person who wants to take an action, then individually Mr. X can take an action against the company. If there are Mr. X, Y, B, F, D, there are around 200 people or 300 or 500 or 5,000 people, group of people who want to take an action, they can also file an action suit. And any other association of persons, if they are affected by the misleading statement or inclusion or omission in the prospectus, then they can file a case against the company. So all these affected persons can either file the case individually, or group of persons can file, or any association of persons. So have you heard about Satyam case which happened in Hyderabad long back? Satyam Computers का केस हुआ था, किसी ने सुना हुआ है? So when the Satyam case happened, the director, he just failed to pay his huge liabilities and then he said that I can no longer take it. So in that case, number of people were affected. So section 37 became applicable in that case, and all the class of people together filed a suit. One of the person can act as their representative and all of the person together filed the suit. Section 37 has paid for class action. So class action suit is for the group of people who want to file a case against one defendant for the common harm done to the entire. सबको एक ही साथ नुकसान हुआ था सत्यम केस में, तो उन्होंने इकट्ठे ही केस फाइल कर दिया था कोर्ट. M applies for equity shares on the basis of prospectus which contains misstatement. Shares were allotted to him. Now afterward he transferred them to N. Can N file a case on Recision on saying misstatement under section 37? So it says no. You cannot file a case because you have purchased the shares from M N cannot file a case for the rescission of the contract because of buying the shares from M. Section 37 does not become applicable because it is a suit which is filed under Section 34, 35 or Section 36 by any group of firms. Therefore, only M is eligible to file a suit. N cannot file a suit. समझ आ गया? पढ़ लो इसको 2 मिनट लगाकर. कोई डाउट है तो पूछो. हाँ जी, चले आगे. अब आते हैं सेक्शन 38. Yes, Anil, because it's not a primary purchase, so section 35 attract ही नहीं हो रहा. So जब section 35 ही नहीं attract हो रहा तो 37 तो आएगा ही नहीं. Swastik Gupta, what happened, beta? I can see all your messages. You are here only in the class. You are in the Zoom app only. And the WhatsApp group link is given over here. Have you got Swastik? Aren't you there in the main chat? Okay. Now punishment for personation. So section 34 में गड़बड़ करी, misstatement करा तो 447 लग जाएगा. Section 35 में loss या damage हुआ तो 447 लग जाएगा. Section 36 में 3 cases के लिए induce करा to forcing him to buy the securities or to get certain profits for your friends. Or the third case is you want to avail any credit facilities from bank. तीनों cases में 447. सेक्शन 37 कहता है कि अब 34, 35, 36 में कहीं भी अगर आप अफेक्टेड हो तो आप क्लास एक्शन सूट फाइल कर सकते हो. या तो आप अकेले कर दो, केस फाइल कर सकते हो, या ग्रुप में कर सकते हो, या फिर एसोसिएशन ऑफ पर्संस कर सकते हो. सेक्शन 38 बहुत इंटरेस्टिंग. सेक्शन 38 क्या कहता है? पनिशमेंट फॉर पर्सनेशन. पर्सनेशन का मीनिंग कौन बताएगा मुझे? Raise your hands and tell me what do you understand by the word personation. What is the meaning of the word personation? Personation means fake names, using a fictitious name or something a fake related to the sale and purchase of securities. Mr. Chavan, very good. नकल करना, fake, proxy. Yes, Anil, very good. किसी और का नाम use करना. Very good, Mustafa. Trying to use the name of another person. So personation अगर कोई करता है तो उसके लिए भी पेनल्टी है. अगर आप फेक नेम यूज कर रहे हो, आई एम हरलीन कौर but I use the name of, I filled the share application with the name of Aishwarya Rai, so I'm using a fake name, fictitious name. If again 447 will become applicable. आपने किसी तरह की पर्सनेशन करी 34, 35, 36, 37, 38 पांचों सेक्शंस में 447 is there. आपने किसी, दिस इज टू प्रिवेंट द अलॉटमेंट ऑफ शेयर्स इन फिक्टिशियस नेम्स. फिक्टिशियस नेम्स में शेयर्स अलॉट ना हो जाए, इस करके सेक्शन 38 बनाया गया. Any person will be liable for punishment if he makes or abates the share application in a fictitious name for acquiring, subscribing the securities. अगर आपने कोई भी शेयर एप्लीकेशन अपने रियल नाम में नहीं करी बट किसी फिक्टिशियस नेम में करी, then in that case 447 will become applicable. This is the first case of personation. You made multiple applications by using different combinations and names. Aishwarya Kapoor, जॉन इब्राहिम का आपने क्या कर दिया, शाहरुख अब्राहम। मिक्सचर कर रहे हो, मल्टीपल एप्लीकेशंस, डिफरेंट नाम से गलत मतलब दे रहे हो, कॉम्बिनेशन ऑफ हिज नेम और सरनेम, जस्ट फॉर एक्वायरिंग और सेलिंग द शेयर्स। अगेन मल्टीपल एप्लीकेशंस फॉर फेक नेम्स। फेक फिक्टिशियस नेम से अपनी एप्लीकेशन दे रहे हो या फिर मल्टीपल एप्लीकेशंस दे रहे हो फेक नेम्स के साथ। और यू आर inducing a company to allot or register transfer securities in a fictitious name. Otherwise induces a company, कंपनी कर रही है fictitious name, कंपनी को कहा जा रहा है कि आप शेयर्स अलॉट करो fictitious name. So every individual who is using a fictitious name in application for shares, or he is using multiple applications in false name, or if he is inducing a company to allot the shares in fictitious name. Second is using different combinations. First is individually. Second is using different combination of different fictitious names and making different applications. Third is a person includes company's name. Company has used fictitious name for share application and allotment of shares. Then all of them will become liable under section 447. Every company who is required to issue prospectus to reproduce prominently the provisions of subsection 1 in the prospectus in every share application form of securities. A person who gets shares allotted in fictitious names becomes liable as shareholder where the person carries on the business under the assumed name and took shares. This trustee bankruptcy could not avoid the liability. सारों को ही liable होना पड़ेगा. अब आ जाते हैं बहुत इंपॉर्टेंट बात, सबसेक्शन 3, where the person who has been convicted under this section, जेल हुई उसको 447 में कि आपने फेक नेम यूज करा. First of all, for this penalty, every company will have to write that if anyone gives a false name or fictitious name, they will become liable under 447. This has to be written in every share application. इसका मतलब ये. Company while issuing the prospectus, prominently उनको लिखना पड़ेगा every share application form में कि that if you give a fictitious name, then you will become liable under 447. तो पहला पॉइंट है, 3 केसेस में 447 लगता है. अगर आप ऐसे करते हो इंडिविजुअली फेक नेम, combinations of fake name or companies using fake name for the share application and all. फिर कहता है कंपनी कहेगी कि आपको हर प्रोस्पेक्टस में शेयर एप्लीकेशन फॉर्म में लिखा होगा कि that 447 will become applicable if you give false information of it. थर्ड क्या कहता है, डिसगॉर्जमेंट के बारे में. डिसगॉर्जमेंट क्या होता है? What is the meaning of disgorgement? Disgorgement means to take it out. वसूल कर लेना हिंदी में. अगर किसी ने भी कोई प्रॉफिट कमाया है, anyone who under section 38 by using the fictitious names for the share application has earned any gain or profit, then government or court can disgorge that gain. Disgorgement means पूरा का पूरा ले लिया जाएगा. Whole of this profit and gain can be taken from this person. Whole money, the government can take full amount from this person. So all the affected persons under section 37 में क्या था? All the affected persons can file a class action suit against the company. Section 38 में कहा जाता है डिसगॉर्जमेंट हो जाएगा. किसी ने भी अगर कंपनी से फायदा उठा के fictitious names and fake names use करके प्रॉफिट कमाया है, with the person has been convicted, court may order disgorgement of any gain. The order may include seizure and disclosure of securities also. Amount so received will be credited to Investor Education and Protection Fund. MCQ का क्वेश्चन बन सकता है. MCQ में क्या क्वेश्चन आ सकता है? Under section 38, all the amount of the convicted person will be disgorged by the government, any gain made by such person. This amount of disgorgement shall be credited where? To the IEPF account, Investor Education Protection Fund, जो कि हम चैप्टर नंबर 7, 8 आगे जाके इसके बारे में पढ़ते हैं. I hope Vedant now disgorgement is clear. Disgorgement means to take it out, to release everything. Means whatever profits you have gained. So I used a fake name and I on the share application form and I subscribed to the securities. Further, I sold the securities and earned huge profits because I've used a fake name. So now whatever profits and gains I have made by using this false name, government will take out all the profits from it. Disgorge कर लेना means पूरा का पूरा ले लेना. पूरा पैसा जो भी आपने कमाया है, गवर्नमेंट कैन टेक दैट फुल. डिसगॉर्जमेंट का जनरल मीनिंग होता है टू लेट आउट समथिंग, टू कंप्लीट completely taking out anything. So वो आपका फुल गेन आपका ले लिया जाए. यस सतीश बिल्कुल सही. रिटर्न कर देना. वेरी नाइस साफिया. पी मुजाहिद. ये कहां से आपने वर्ड उठाया? पी मुजाहिद कहाँ पे लिखा है? आई थिंक देयर इज सम केस लॉ दैट यू आर रेफरिंग. विच पेज? ओके फर्स्ट लेट्स कंप्लीट 447. अब आ जाते हैं हम पनिशमेंट फॉर फ्रॉड. तो आपने किसी में भी अगर सेक्शन 34 में दिक्कत करी, सेक्शन 35 में दिक्कत करी, 36 में दिक्कत करी, 37 में प्रॉब्लम आई, एक्शन हो गए, एंड सेक्शन 38 में पर्सोनेशन करा, कोई भी ये चीजें करा और उसमें फ्रॉड इन्वॉल्व, फ्रॉड के नजरिए से करा है, 447 इज द पनिशमेंट फॉर फ्रॉड. इनकॉर्पोरेशन ऑफ कंपनी में भी हमने पढ़ा था ना, अगर फ्रॉड करती, अगर आपने फ्रॉड की इंटेंशन से करा है तो उसकी 3 पेनल्टीज हो जाती. कैसे याद करेंगे इसको? नंबर 1, where the fraud is less than the limit. First, you will have to learn the limit with me. What is the limit? 10 lakh rupees or 1% of the turnover. 10 lakh rupees or 1% of the turnover. Suppose the turnover is 10 lakh. तो 1% कितना हुआ उसका? Suppose the turnover is 10 lakhs. तो उसका 1% हुआ. जल्दी in the chat box. Yes, P मुजाहिद, प्रॉफिट वापस देना, रिटर्न करना, बिल्कुल सही. 1000. $10 lakhs, the 1%, 10,000. Satish, not 1,000, it's 10,000. So now 10 lakh और 1% of turnover एक लिमिट होती है. अब हमारे पास 10 लाख का था टर्नओवर, तो हमारा ये 1% ऑफ टर्नओवर आ गया 10,000. अब इन दोनों में से क्या लेना होता है? whichever is lower. इन दोनों में से हमेशा ही whichever is lower लेना. So what will be whichever is lower? 10,000. So if my fraud is less than 10,000, suppose my fraud is 9,000, then maximum penalty 50 lakh rupees and jail up to 5 years. 50 lakhs, 5 years. 50 lakhs, 5 years. If my fraud is more than 10,000, my fraud is 15,000 rupees. And public interest is also involved. And public interest is not involved. Then equal to the amount of fraud, 3 times the amount of fraud. Minimum तो लगेगी 15K. Maximum कितनी लगेगी बेटा? 45,000. 3 times of the amount of fraud. अब अगर public interest involved है तब भी same है. Equal to the amount of fraud 15,000 and 3 times is 45,000. एंड अगर मेरी पेनल्टी ज्यादा है, मोर है, ये वाला केस मोर का है, और पब्लिक इंटरेस्ट इन्वॉल्व नहीं है, तो 6 मंथ से 10 ईयर तक मुझे जेल करेंगे. और अगर पब्लिक इंटरेस्ट भी है तब 6 मंथ्स, 3 का डबल होता है 6, बट ईयर का हाफ होता है मंथ्स. 3 years and 10 years कर देंगे अगर पब्लिक इंटरेस्ट इन्वॉल्व है, पब्लिक इंटरेस्ट है तो ज्यादा बड़ी चीज, 3 years से 10 years। पब्लिक इंटरेस्ट नहीं है तो 6 महीने तक की जेल से लेकर 10 साल तक की जेल हो सकती है। बट अगर फ्रॉड ही छोटा है तो 50 लाख 5 years, 50 लाख 5 years, ये तो 5 से याद हो रहा है हमें। 5 10 50, 50 लाख 5 years, 50 लाख 5 years। सो अगर फ्रॉड कम है, पहले तो लिमिट लर्न करनी है, 10 लाख रुपीज और 1% ऑफ टर्न। एंड फ्रॉड लेस है, पब्लिक इंटरेस्ट इन्वॉल्व नहीं है, ठीक है ना। यहाँ पे पब्लिक इंटरेस्ट दोनों केसेस में नहीं है, ऊपर वाले दोनों केसेस। यहाँ पे भी पब्लिक इंटरेस्ट नहीं है, यहाँ पे भी पब्लिक इंटरेस्ट नहीं। तो फ्रॉड तो 50 लाख है, 5 साल की जेल। यहाँ पे पब्लिक इंटरेस्ट नहीं है बट फ्रॉड ज्यादा है लिमिट्स, तो अमाउंट इक्वल टू फ्रॉड और 3 times। एंड इज वेरी इंपॉर्टेंट, जेल भी होगी होगी। कम वाले में एंड और है, मर्जी है, जेल होगी नहीं, बट इसमें 6 months से लेके 10 साल जेल। एंड अगर पब्लिक इंटरेस्ट इन्वॉल्व है, चाहे वो मोर है चाहे वो लेस है, चाहे वो मोर है चाहे वो लेस है, पब्लिक को धोखा दिया, पब्लिक इंटरेस्ट इन्वॉल्व हो गया, 3 से 10 साल जेल। एंड फ्रॉड सेम रह रहा है, 3 times एंड इक्वल। समझ आ गया? टेस्ट ले लो पेनल्टी के ऊपर, फ्रॉड के ऊपर, जल्दी बताओ, समझ आ गया सब? ओके, केस नंबर 1, if the turnover is 1 crore rupees, calculate the limit first. If the turnover is 1 crore rupees, calculate the limit. So 1 lakh or 10 lakh, whichever is less. क्या आएगा लेस फिगर? लिमिट कितने की सेट हो गई? 1 lakh और 10 lakh? 1 lakh? Everybody in the chat box, 1 lakh. Oh, Mustafa, why are you writing 10 lakhs? Sabya, good. Yes, very good. Satish, Chavan, everyone, 1 lakh. Now, case 1 is, if the fraud is 2 lakh rupees and it involves public interest. If the fraud is 2 lakh rupees and it involves public interest, what will be the penalty under 447? Raise your hands and answer me. Very good, Sham. Yes.
Ma'am, in this case, public interest involved, so the amount will be equal to the fraud, that will be 2 lakh, and 3 times that will be 6 lakh, or it involves the imprisonment minimum 3 lakh,
or
and 3 years or maximum 10 years.
Because public interest आ गया तो 3 years 10 years तो रख लेंगे। And एक चीज आपने नहीं बोली बेटा, minimum fraud is 2 lakhs, maximum fraud is, oh sorry, minimum fraud is, how much fraud did you say? Minimum is 2 lakhs, maximum is 6 lakhs. Yes, Julie Kumari.
Good evening, ma'am. My answer will be same. Yeah.
My answer will be?
Yeah. What earlier student has explained, my answer will be as like.
No, my question is different from you. So, Julie, you have to answer me case 2. Now my penalty is 90,000 and no public interest is involved.
Okay. Then
Sorry,
in that case, up to 5 years or yeah, a fine will be 50 lakh or 5 years both.
So 90,000 तो नहीं ना होगा जितना fraud है. If public interest is not involved, we have a fixed penalty of 50 lakhs.
50 lakh. Yes.
Confuse you and you got confused. So your answer is correct, Judicial. Good. And now who is going to answer me if the fraud is, हमारा 1 lakh का limit set हुआ हुआ है. If the fraud is 3 lakh rupees and no public interest is involved. Fraud is, the limit we have set is 1% of turnover, that is 1 lakh or 10 lakh, whichever is less is 1 lakh. And my fraud is, yes, Mustafa, would you like to answer it?
Equals to amount which is 3 lakhs or minimum amounts. It is 3 lakh or maximum 3 times 9 lakh. And jail of 6 months minimum or maximum 10 years.
Mustafa, mute yourself. Yes, Savya. So I was muted you all now. Hanji. So excellent. Savya, you wanted to say something? So 447 says, in relations to a company or body corporate, any act, commission or concealment committed by a person or any other person with the intention to deceive or gain undue advantage or injure the interest of the company or shareholders, whether or not there is any wrongful gain or loss. चाहे आपको फायदा हुआ या नहीं हुआ, अगर आपने कोई भी omission concealment करी तो वो fraud. Underline this word, whether or not there is any wrongful gain. What is wrongful gain? Unlawful mean use कर आपने gain करा, lawful mean से आपको loss हुआ. So fraud related to company is any act, commission, concealment of the facts committed by a person or any other person trying to take undue advantage, injuring the interest of another person. किसी को नुकसान पहुंचाना, हानि पहुंचाना, cheat करना, चाहे आपको gain हुआ या loss हुआ या नहीं, कंपनी को, shareholders, creditors को, किसी को भी अगर आप करते हो तो fraud बन जाए. Read this illustration and give me, raise your hands for the answers. Everybody, I give you 2 minutes. Read this illustration and raise your hands for the answers. Everybody has to answer. What would be your answer? Raju is one of the prospective investor under Section 37. He sued the person who has authorized the prospectus for fraudulent misstatement. He also filed a complaint and Section 447. Mr. Angad, one of the authorized person, plead that Mr. Raju did not take any share. Hence, he has not suffered any loss. Therefore, he should not get any remedies for what he's asking and not punishable under 447 because fraud is not committed against him. Whether the person who has authorized the issue of prospectus punishable under 447? Yes, Mrs. Savya.
Ma'am, the people will be punishable, the person will be punishable because there is, whether there will be a wrongful gain or wrongful loss or not, the person will come under the category of they have made misstatement.
Excellent. Very good. Very good. Very good. Everybody got clear on this one? So it's 8 p.m. Let's take a small break because I want to do a number of questions with you and then we will be taking many of your writing also, ma'am. Small break. Yes, Deepika, bilkul theek answer hai aapka bhi. Very good. So let's take 5 minutes break and then we will continue with the questions. Fatapat se ek bari pad lo. Mustafa, I hope you have understood. Yes, it will be liable. That's good. Anil, all your answers are correct. Anil, your all answers are correct. I have read your answers. Prerna, your all answers are correct, bacha. Shamli Sharma, your answer is correct. Vaishnavi. Deepika, good. All right. Let's take a small break and then we are going to do, nobody will leave the class because we're going to do very, very important questions. फटाफट से इसको पढ़ लो and पे questions करेंगे. Nisarak sir, we are just taking small break over here. All right, students, let's proceed ahead. Okay, somebody's writing a query. Yes, Anil, in the first case, that will be correct if the amount is less. In the second case, we are talking about the amount which is more. Now we have completed section 37, section 38 also. Before going to section 39, let us do some important questions. With a view to issue shares to the general public, a prospectus containing some false information was issued by the company. Mr. X received a copy of the prospectus from the company but did not apply for the allotment of shares. The allotment of shares to the general public was completed. Few months later, X bought 2,000 shares from the stock exchange at a higher price, which later on fell sharply. X sold these shares at a heavy loss. Now he wants to claim the damages from the company for the loss suffered on the ground of the prospectus issued by the company, which contained a false statement. Please tell us whether X can claim this damages or not. Who is going to answer me? Okay, Mustafa, we have muted everyone now, not a problem. Yes, Julie.
Okay, in this case, Mr. X cannot claim damage from the company for the loss suffered on the ground of the prospectus because Mr. X has bought the shares from the stock exchange market, not on the basis of the prospectus that is issued in the primary market.
Excellent. So
As
which
per the
case
Pick
will be
versus Gurnekish.
very nice, very good, very good. Yes, Jaya, is she correct?
Yes, ma'am.
Anything else you would like to add?
No, ma'am, it is like that. And only we can claim the damages if he purchased the stocks on the basis of prospectus.
Very nice, very nice. Excellent. Both of you have answered it beautifully. Good. And many have written the correct answer in the chat box also. So well done. Arun Kumar is asking in the table of fine for punishment for fraud, 50 lakhs means the fine amount will not exceed 50 lakhs. Fine will depend very. So that is the maximum limit, Arun. Yes, that you're correct. It's the maximum limit of 50 lakh fine that is given. Yes, Mustafa, absolutely correct. Yes, he cannot claim. That's the correct answer. Sangeetwani, your answers are correct. Fatima. Anybody else who has written for this one? Okay, so sweet of you, Harsh Mishra. The way you taught and taking questions after completing of sections give very clarification. I hope you are with us all the way. Definitely, Harsh Mishra, I'm so happy to read your beautiful comment. And children, this is your beautiful motivation that keeps me also going and keep coming up with these beautiful things for all of you. Thank you, Harsh Mishra. It really means a lot. Hanji beta. So I have displayed the answer in front of you on the screen. Please kindly read it, all of you. You can have it a look. Shall we move to the next question? Read the question number 5 and raise your hands for answering. Very good, Mustafa. Answer me.
Ma'am, this question is already done. Under section 31, self prospectus is been issued and with information memorandum within
Okay.
1
So
year.
my question is, isn't there any problem that debentures have come up over here?
No, ma'am, because it
Why?
is also a security.
Excellent, excellent, excellent. Very good. Good, beta. So everybody recall, debentures are also part of security and share prospectus will be considered. Have we done this one also? Please, somebody tell me a bridge prospectus. I think we did the bridge prospectus. Okay. Yes. Question number 7 we have not. An allottee brought an action against the director because of misstatement in prospectus. Director contended that the statements were prepared by the promoters. Now, we have just read about this illustration in the module. I wanted to show you how you have to write your answer. So you will say, yes, the directors will be held liable under section 34 and 35. Section, Julie Kumari, unmute yourself. Only situation where director will not incur liability is if he proves that the omission was immaterial or he had the reasons to believe that something which is true. By just saying that he has relied on the promoter is not an excuse. All right. So this is where your writing comes into practice. You have to write in the exam. Having consented to become no civil liability if you have consented to become a director, it was issued. In the present case, he cannot hide behind by saying that he has relied on the promoters. So it is not a valid answer. Correct? Let me see if we have something more for you. Okay, anyone having any doubts still here? Because I will be starting with section 39 soon. So all your cases are for irregular allotment after this. Let's have a quick go through from the study also. Board of Directors of Chandra Mechanical Toys Limited issues a prospectus inviting public for subscribing the equity shares. The reports, again, this deals with your section 26. You all know this one also. All right, I think let's start with section 39 and then we can jump back to the questions. Now, what is the meaning of section 39? Day one, when we started the chapter of prospectus, I told you that when I, as a company, I have come up with the issue of prospectus in the market, that is an invitation to offer. Remember Indian Contract Act, what is invitation to offer? Display of products in the market, in the shops, right? Or when we are just inviting the public to come and buy the shares in my company, I am not giving any offer. I am just inviting the public to come and take up these shares in my company. Now, I am a company ABCD Limited and I have issued the prospectus. So I have given invitation to offer to the public. Mr. X and Y sent me the application that, yes, ma'am, we want to apply in your company. So that application So when we are receiving these applications, that is known as offer. The company gives the allotment of securities, that is the acceptance. So I sent you the invitation to offer and you gave me offer on that. I, company, gave you an acceptance. And when offer gets accepted, it becomes a, and when the offer gets accepted, it becomes a contract. It becomes a contract. Very nice. All of you agree that when it gets accepted, it becomes a contract. Now it's a valid contract between the companies and the shareholders. Harsh, we'll be covering most of them in the class itself only, so don't worry. Okay. A company can allot the shares to the public only when the amount stated. Now, when do an allotment means? Appropriation of unappropriated capital of my company. So I have 1 lakh shares, out of which 90,000 shares have already been subscribed. How much balance is left? 10,000 shares. So this is my unappropriated capital, which is still left to be allotted. So whatever is the amount of full 1 lakh has to be allotted. So these 1 lakh shares have to be previously, which was unappropriated, has to be divided and given to the public. Number one, company will allot shares to the public only when the minimum subscription has been received. ये ध्यान से सुनने वाली बात है बच्चा. Section 39 I've started with you. Pay attention. Sangeetvani, your answer was absolutely correct, beta. I've just read it. Very good. The main problem is now I have to go into each of the person's chat and read. Vedant, I hope my voice is clear to you now. Mr. Chavan. Okay, thank you, Mr. Chavan. We'll make sure. Okay. Prerna, he cannot because, right. Let me just flip through the chats because then something might be left. Everything is clear. Okay, Shamli, good. It becomes a contract. That's correct. Jaya Manocha, contract. So, beta, what is the meaning of the word minimum subscription? Minimum subscription and minimum application money. Have you read about these words before? Have you heard when I told you that we will be talking about minimum subscription and minimum application when we do section 39? हमने कहीं पढ़ा था कि minimum application is not applicable, minimum subscription is not applicable. जल्दी से लिख दो कौन से section में था? Which was the section? OFS, Julie, Shamli, Savya, excellent. Offer for sale ki exception. Mr. Chavan, very good. Everybody has answered it correct. Mustafa, very good. So now we'll understand what is the meaning of the word minimum subscription. So company will allot the shares to the public only when the minimum amount has been subscribed and the minimum application money has been paid. Now this minimum application is actually given by SEBI. So it should not be less than 5% of the nominal amount of securities or any other amount which SEBI has notified. As of now, SEBI ने क्या बोला? 5% of nominal amount से कम नहीं होना चाहिए. So अगर मेरे शेयर का nominal amount ₹10 है, तो 5% of nominal amount कितना होगा? जल्दी बताइए. 0.5. Absolutely correct. Everybody is at least 0.5 should have been received on my shares. So what you have to remember is application money, at least 5% of the nominal amount or any other amount specified by SEBI should have been received. Then only I will allot securities. Minimum subscription, as of now, it is 90% of the amount should have been subscribed, which keeps on varying because we have to follow SEBI guidelines first. So whatever is the minimum amount, it should have been subscribed, means 90% of the shares should be taken up by the public. And those shares which they have taken up, at least 5% of the nominal value should have been received as a share application money. Then only I can proceed further for the allotment of securities. And if this minimum amount has not been subscribed and the sum payable on application has not been received in 30 days or any other period as specified, मतलब वो बोल भी रहा है 30 days, फिर कहते हैं जो भी सेबी कहेगा. ऐसा क्यों कह रहा है वो? क्योंकि कंपनीज एक्ट हमें प्रोसीजर बता रहा है. स्टॉक मार्केट की फुल डीलिंग इज विद सिक्योरिटी एंड एक्सचेंज बोर्ड ऑफ इंडिया. इट कीप्स चेंजिंग देयर लॉज. सो कहते हैं एज ऑफ नाउ विद इन पीरियड ऑफ 30 days अमाउंट आ जाना चाहिए, या फिर whatever amount, whatever date SEBI has given from the date of issue of prospectus. If you have not received the amount within 30 days, return the amount to the applicants. When the company having share capital will make the allotment of securities, they need to file a register having a return of allotment and TAS3. इसके बारे में अगली क्लास में बात करेंगे. 4th point छोड़ दो. एंड अगर आप कोई भी डिफॉल्ट करते हो सेक्शन में, पेनल्टी, एक हमने कंटेंट सेक्शन 26 में करी थी पेनल्टी, एक हमने बीच में और करी थी, अब सेक्शन 39 में करे. 447 को क्लब कर लेना सेक्शन 34 से लेके 38 की कंबाइंड पेनल्टी. ठीक है, उसमें भी करी थी अब्रिज्ड प्रोस्पेक्टस में 50,000 पर डिफॉल्ट. ये तीसरी पेनल्टी. फॉर पेनल्टीज आई एम अगेन रिपीटिंग, आई हैव मेड एन अनाउंसमेंट अर्लियर आल्सो. एज एंड वेयर द पेनल्टीज कीप कमिंग, यू विल मेक अ सेपरेट शीट, write down the section and write down its penalties and stick it on the front page of the chapter, so that whenever you are going to read prospectus, you will first go through all the penalties. It will help you to quickly memorize the things. In each chapter, follow this rule, write the penalties on a separate sheet and stick it on the near the first page of the chapter. So section 39 की penalty है, every company and every officer in default 1,000 per day or rupees 1 lakh, whichever is less for each default. So 1,000 per day. Suppose the default continues for 30 days. 1,000 into 30, 30,000. Or 1 lakh, whichever is less. So 30,000 will be your penalty. Clear? So the minimum subscription should not be less than 90%. And the application money that is to be received shall be received by check or any other negotiable instrument, but not cash. So two conditions होती है सिक्योरिटीज अलॉट करने से पहले. आपके पास मिनिमम सब्सक्रिप्शन का पैसा आ जाना चाहिए, क्योंकि 90% of the money should have been received, and whatever application money you're receiving should be coming in check form and not cash. If no allotment is made, so amount shall be received in 30 days. So time period क्या कहता है? 30 days में हमें amount receive करना. If it is not received, no allotment is made, refund the amount in 15 days. If it is not refunded, then directors are jointly and severally liable for 15% per annum interest, and the amount shall be refunded in the same amount from which it has been received. I understand we have already done so heavy penalties today, and we had a quick recap of the entire chapter also. Broadly, we are left with section 39, 40, 41, and 42, and whole of your practice questions. I'll be giving you lots and lots of practice questions, which we're going to do in the class itself. So I'll just briefly wind up section 39. I'll be taking up whole of the section 39 in the next class, since we had time, so we just started. So two things you have to learn in section 39. One is prospectus is invitation to offer. When the share application is received, we get the offer and company allot the securities. It is accepted. It is not working. Hello, am I audible? Offer comes in touch with the acceptance. It becomes contract. Okay. So once the contract becomes, means allotment of security. Section 39 में हमने सारा prospectus पढ़ लिया. Subscribers ने, investors ने देखा, अब वो shares खरीदने आ रहे हैं, अब company ने section 39 में securities allot कर ली. We're just very close to completion of public offer, and then we will be jumping to private. So for allotting the securities, two conditions only I've taught you as of now in section 39. Minimum subscription should have been done, that is 90% as per SEBI. And what is the minimum application money should have been received? What will you write? How much minimum application money should have been received? 5% of what, Kuldeep? Yes, Shamini, 5% of the nominal value of shares or any other amount specified by SEBI. Good, Sangeetwani. Yes, Jaya, good. So well done, students. You all have been responding and answering very beautifully along with the chapter, which really makes me feel happy and it gives me boost my energy also so that I can ask you more questions. Anyone still having your doubts? We have 1 minute left. You can raise your hands. Anyone having any doubts? Thank you, Shamli. I'm glad you're finding law easy now. And law is actually easy. You just have to keep learning it. Okay, Mr. Chavan. Anybody having any doubts, children? Yes, Savya.
Ma'am, I have a doubt in that less than 10 lakh and at least 10 lakh means the amount of penalty. There is some.
So it basically means the first part where it is written lower than this. Lower than this, you understand 50 lakhs in 5 years, you understand that part. At
Yes, ma'am.
least means at least itna hai zyada. You said your
Yeah.
mom, at least get me 10 chocolates. So 10 to minimum हो गया ना. अब यहाँ तो वो 12 लाएंगे या 15.
Ma'am, but you have given one example of 3 lakhs that will fall under the first one or the second one.
So
3
what was the
lakh.
limit? What was the limit that we have set at that time? Because I changed the question in between. Now, one, we have set the limit of 1 lakh, another was different. So again, I'll give you an example, 10 lakhs or 1% of turnover, whichever is lower. So first you have to set the limit for turnover. So turnover is 10 lakh, uska 1% kitna hua? 10,000?
Yes, ma'am.
So 10,000 or 10 lakh, whichever is lower, 10,000.
10,000.
Now, if your fraud is 9,000, fall under first head, 12,000, fall under second head. Public interest involved in either of the cases, fall under.
Okay, ma'am. Thank you, ma'am.
Welcome. All right. I hope nobody has any doubt. Thank you, Julie Kumari, for such a wonderful comment. God bless you all. Keep studying, keep revising. I'm just going through the chat box. Hope there is no more query left over there. Thank you, Harsh Mishra. I'm glad, no doubts. Thank you, Fatima. Keep answering also. Thank you, P. Mujahid. So everybody has learned prospectus, I believe now. Huh? That's great. Good. All right. I can only see thank you messages now. No more queries. So I think we can wind up the session. Thank you, sir. Yes, Priyanshi, that will also happen. Don't worry. Okay, Anil, remind me in the next session. We will have a tip for penalties also. Don't worry. So we are done with the session.